Okay, with that, we're going to move over to the leave bills, and we'll turn it over to Anne here to talk about SB 1383.
Thanks, Anthony. So there has been an overhaul of the California Family Leave Rights Act, otherwise known as this CFRA, and it is really going to have a monumental impact on many employers throughout the state. The new law now requires employers with as few as 5 employees to provide up to 12 weeks of unpaid job-protected leave during any 12-month period for certain covered reasons. And the group of family members included has also been expanded so that it no longer just includes a spouse, a parent, or a child, but employees can take leave to care for grandparents, grandchildren, siblings, domestic partners with a serious health condition. Significantly, this will come into effect on January 1. And there's a lot of new details in this law that larger employees who are already subject to CFRA need to familiarize themselves. And for small employers who, for the first time, will be subject to this law, this really is the time to start gearing up and understanding the law's requirements and to prepare for it. So on this slide, here's some of the major changes. First one, it changes the threshold requirement to employees with 5 or more employees. It also extends the definition of the family members, as I've just stated. And it requires an employer of both parents of a child to grant up to 12 weeks of leave for each parent for the birth, adoption, or foster care placement of a child. Under the existing law, where both parents were employed by the single employer, the employer was only required to provide up to 12 weeks for the one employee. This new requirement effectively repeals the new parent law that went into effect a couple of years ago. It's now redundant since this new amendment provides even broader coverage. Also, the expanded CFRA eliminates the key employee provision under the current law. Previously, there was an option that key employees could be, their job didn't have to be left open during their leave. So some basics on the eligibility for CFRA leave is that the employee must have worked for the employee for at least 12 months and worked at least 1,250 hours in the 12-month period before taking the leave. It is up to 12 weeks. It's unpaid, and it can be taken in increments on a monthly basis, on a month, a week, and even on an hourly basis. Remember, this leave is in addition to any other leave that's mandated under California law. So a pregnant employee is still entitled to take the pregnancy disability leave for 4 months, as well as the 12 weeks, say, for baby bonding. And the reasons, or what's required under the new leave laws, is that the leave can be taken because of the employee's own serious health condition or to care for those expanded family members under this amendment. Now, while the employee is out on leave, they must continue to receive the same health benefits at the same level had they been not out on leave. And then importantly, upon a return from a leave under CFRA, employers must reinstate the employee to the same job or a comparable job to the extent that the employee would have remained in that position if they had been continuously employed during the leave. And this, some people may be thinking, oh, this doesn't really impact larger employers because I've already been subject to the CFRA, but it actually does. As we've already talked about, there's additional covered family members, there's expanded reasons for the leave, and importantly, the threshold requirements of employing 50 or more employees within a 75-mile radius has been stricken. So what that effectively means is larger employers who have small work sites will now be, who may not have been required to provide CFRA before, now will be required to permit the CFRA leave. And this also has an impact on the larger employers to the extent that under some circumstances, the leave will no longer be concurrent between CFRA and the federal FMLA leave. As an example, the employee may take 12 weeks to care for a sick grandchild and then take an additional 12 weeks under the FMLA for his own serious medical condition. So there's a lot of things both large and smaller employers need to do to get up to speed with these very complicated and intricate requirements under the leave law.
We had a question come in too, how long is the leave again? It's the 12 weeks, right?
Up to 12 weeks in a 12-month period.